The sixth and final element of a valid contract is intent, and it means that the parties need to have actually had the same picture in each other's minds when entering into an agreement, so that we know they have mutual assent. And if one party does something sneaky, tricky, rotten, etc., then the other party is not validly entering into a contract. There's no intent to enter into the same agreement, and there is no contract. So we're going to look at fraud, misrep, duress, and mistake. I can tell you that fraud is the number one tort that is often brought along with breach of contract cases. And the reason being is that if you have a tort theory in your complaint, you can often ask for punitive damages, whereas if you just have a contract theory, you cannot. So fraud is an intentional wrong. It's a tort. It's different than a contract theory, and you can have punitive damages with it. Here's the definition of contractual intent. The parties to the contract must actually intend to enter into a contract for the same bargain at the same time. These are the 5 elements of contractual fraud. If you do not have all 5 elements, you do not have fraud. Typically, what is missing from these 5 elements would be proof of the intent to deceive, which is element number 3. And if that intent is missing, then you merely have misrepresentation, which we'll talk about in just a minute. So if someone was to prove fraud, they have to prove all 5 of these elements. And it can be difficult to prove what was in the mind of somebody else. Speaking of point 3, the intent to deceive. Say your mother goes in to buy a diamond ring. She loves diamonds. And she is sold a paste or fake diamond. It's not a real diamond. If the person specifically said this is a diamond, that would be a misrepresentation of a material fact. How do we prove the intent to deceive? Well, we allege that in our complaint with as much detail as possible, and then we ultimately allow excuse me, the jury to find out and make their decision as if there was intent to deceive. You might look at facts such as, should the other party have known it wasn't a diamond? Was it in a box that said cubic zirconia that he removed the label on? Any fact you can think of that will help establish the intent to deceive will allow a jury to make that decision. And then obviously it was relied upon by your mother to her detriment. She paid a lot of money for that. It wasn't a diamond, so that's fraud. And it's also a breach of contract at the same time. You've got 2 theories going on. So what's the difference between fraud and misrepresentation? The intent to deceive. That is the only difference. In that case, the innocent party may avoid the contract. Your mother can get her money back, return the cubic zirconia, or she can force it to be fulfilled. Say it was a unique diamond and she really wanted that particular diamond. Assuming it existed, she could get an injunction that would require the jeweler to deliver the jewel to her. Let's look at this example. Guy purchased a thigh master for his sister, which is a machine that parties move their thighs to make them stronger. Unbeknownst to him, this was not the Suzanne Somers famous product, but a cheap knockoff. Is there fraud? What facts would we need to know to determine if there is fraud or a mere misrepresentation? Well, I can tell you that as the lawyer, I would think immediately of alleging fraud, but there's a rule in civil procedure, I think it's Rule 9, that says you have to allege fraud with specific particularity. You have to be very specific with as much detail as you can to enable the court to determine if there's a valid complaint for fraud. So let's see, is there misrepresentation? Well, in order to know that, we'd have to know how the box looked. Was it attempting to capture the look of Suzanne Somers' Thigh Masters? Was it attempting to have the look and feel so that the consumer was confused? Was that material? Well, Guy would have to argue and submit proof that he intended to buy a thigh master in particular, not just any old exercise machine. That's the thing he wanted. Was it made with the intent to deceive? Well, we don't know what was in the mind of the defendants, and sometimes you have to wait until discovery to find that out. So Guy would have to allege that it was knowing. And the way he would allege that is he'd say, well, look, they did all these things to make it look as if it were a Thigh Master, legitimate Suzanne Summers product. And he'd say, look at the box color, the look and feel, look at the way they're attempting to trick the consumer. And then ultimately the jury would have to decide if the intent to deceive was in the defendant's mind. He's going to have to prove that he relied on the misrepresentation. If he just went to the store to buy any old exercise machine, then he didn't actually rely on the fact that this was that he thought it was a Thigh Master, which is the misrepresentation, and it's to his detriment. So he's going to have to prove it was a cheap knockoff. You can see how all these elements come into play, and you have to allege fraud with reasonable particularity. You've got to be very specific. You've got to have as much words, quotes, pictures, anything you can to show that a jury might find there was actual fraud. Well, how is duress different? Well, duress is actually forcing somebody into signing a contract. Uh, In my opinion, you don't actually see this argument very much. In fact, in 20 years of practice as a lawyer, I don't think I've ever seen this argument of duress. But there's physical duress, economic, mental. The typical duress that everyone thinks of is gun to the head. So this example of somebody being cornered with a hot spatula, yeah, I mean, I guess if those are the facts, that would be duress. Again, the theory behind duress is that Peter, in this case, did not really have the intent to enter into the contract. It was his wife's intent to force him into the contract. Then we have economic duress. This is a little more subtle. I guess I have seen this argument once in a case. But the key is that it has to be illegal economic pressure. If it's legal economic pressure, that is legitimate. It's just if it crosses the line to become illegal. Let's look at this example. Okay. It is true that if Sabrina doesn't pay $10,000 to her private school this year, they'll triple the cost to $30,000 next year. They're free to charge whatever they want, so that there's no illegal pressure. It's unfortunate for Sabrina, but it's legal. It's not okay if they say they'll freeze her past transcripts if she doesn't pay $10,000 for her school for the next year. So the problem there is that she's entitled to get the past transcripts for things that she's already paid for. And here they're trying to make her pay for a higher amount for the following year. That is not okay. Mental duress. Well, this is often seen in the situation of wills and trusts when you have elderly people who are sick. This is a true situation. My mom was married to her sixth husband. She's actually on number 7 now. And he was 84 and had oil wells. If he was going to will his property to me instead of his own children, which actually he didn't will it to me, he willed it to my mom, his children, his own children from his prior marriage, could argue that mental duress by my mother undermine the mutual assent necessary for number 6 to form that contract, which is essentially a will. And so number 6, then the argument is that my mom, who's young, beautiful, vivacious, actually compelled him through her wily, manipulative ways to force him to give her his goods instead of giving them to his own children.